I'm Garrett Epps, recovering law professor, former Supreme Court reporter, and legal affairs editor of the Washington Monthly. This is a brief explainer about a term that lies behind the Trump administration's war on federal agencies and federal employees. That term is unitary executive. You may have seen in the news that Trump has announced that he, and he alone, has the power to interpret the law and the Constitution for all federal agencies, including, in his words, so-called independent agencies. What this means is that agencies created by Congress and staffed by experts to fulfill specialized tasks can't do any part of their jobs without approval from political appointees in the White House. This is a major change. It's one that will affect any American who eats food, drinks water, takes medications, or travels by air, rail, or road. So it's worth looking at where it's coming from. Trump supporters justify his executive orders and mass layoffs by citing the idea of a unitary executive. It's an idea that half a century ago was a fringe academic theory. Now it dominates this administration's thinking about the president's authority. The idea takes its initial inspiration from the wording of the Constitution. A specific interpretation of that wording was pushed into prominence in the 1980s by conservative legal thinkers. At that time, the Republican Party seemed to dominate the White House, and Democrats seemed to have a firm hold on Congress. Perhaps not surprisingly then, conservative thinkers suddenly discovered that Congress should have less power and the president should have more. Since that initial enunciation, the theory has become more and more extreme. Trump now claims that he and he alone can direct any federal policy, withhold funds appropriated by Congress, and fire any federal employee for any reason or no reason at all. The theory begins with the fact that no one denies there's only one president of the United States. When the Constitution was framed, the idea of one president was very much in question. Remember that in 1776, we revolted against a king with centralized power, and many of the founding generation thought that a single chief executive would create a new elected king who might become as oppressive as George III. They had rebelled against one king, they didn't want another. However, by 1787, when the delegates met in Philadelphia to frame the Constitution, a strong executive had begun to seem more appealing. In the years since the Revolution began, some states had adopted committees or councils of state to make executive decisions. The central government at that time operated under the Articles of Confederation, the national charter that came before the Constitution. In the Articles, Congress as a whole was supposed to make executive decisions. And when Congress was not in session, an unwieldy committee of states was supposed to make them. The result at both the state and federal levels was often indecision, rebellion, even public disorder. So the delegates at Philadelphia decided early in the convention there would be one chief executive, and that person would be called President of the United States. This is prescribed in the text by the Constitution's Article 2. Pay attention to this vesting clause, as it's called, because it is the source of the unitary executive controversy. Here it is. Quote, "The executive power shall be vested in a President of the United States of America," end quote. Those who favor a strong or even dictatorial presidency focus on those words, the executive power. They argue this means not simply the executive power written in the Constitution, but regardless of the text, every bit of power to execute the laws. Indeed, they say it gives the president even more power than that. Very early in the new nation, some advocates began suggesting that because of the clause, the president had powers the Constitution did not give to any part of the federal government. The executive power, they argued, meant any power that any national chief executive, a prime minister, say, or even a king of another country, might legally have under international law. That is a lot of power, folks. The second part of the clause reads, in a president of the United States. This, the argument runs, means every bit of this sweeping executive power is vested in the president and in the president alone. It is not shared with Congress. It is not shared with any other executive official, they say. The president has direct control of every official of the executive branch, they argue. Congress cannot in any way limit how the president uses that power. What does that mean for us today? Well, for advocates of the unitary executive, it means that Congress can't establish independent agencies, such as the Federal Reserve, the Federal Aviation Administration, or the National Transportation Safety Board. Remember, in Trump's executive order, he calls these so-called independent agencies, which recalls his attack some years ago on a judge he didn't like as a so-called judge. These independent agencies currently have powers granted directly to them by Congress. The National Transportation Safety Board, for example, investigates air crashes and determines the causes. Presidential approval of its findings is not required by the statute that created it. Congress in 1974 made the board independent of the Department of Transportation. The DOT is subject to control from the White House, as well it should be. But Congress in 1974 proclaimed that because the NTSB is in charge of sensitive investigations, it couldn't properly do its job, quote, unless it is totally separate and independent from any other agency of the United States, end quote. The board is headed by 5 commissioners who are nominated by the president and confirmed by the Senate. No more than 3 can belong to the same political party. Each serves a 5-year term. The president may remove a member, but not simply because he doesn't like him or because of a disagreement over policy. The only grounds in the statute for removal are inefficiency, neglect of duty, or malfeasance in office. As a result of this structure, and of hard work by independent officials appointed by presidents over the past 50 years, American transportation accident investigations are the world's gold standard for careful independent safety findings. These findings often lead to technological changes in aviation or changes in the ways airlines operate that had been compromising safety. To a true unitary executive believer, this is all wrong. There can't be any independent agencies that fulfill executive functions. In 2006, President George W. Bush issued a signing statement that asserted the power to withhold publication of parts of NTSB investigations if, in his judgment, making them public could, quote, impair the performance of the executive's constitutional duties, including the conduct of investigations and prosecutions. This claim seems wrong somehow. Military secrets, maybe, but any part of the executive's constitutional duties? The board is created by Congress. Congress sets its functions and membership. How can the president step in and skew or silence the results of its investigations? An unscrupulous president might use this supposed power to censor investigations that reflect badly on friendly corporations, or to make false claims that a former administration is responsible for air crashes when in fact they're the current administration's fault. Or a president might just ignore the restrictions on party membership and replace independent board members with his own partisan followers. Bush's signing statement didn't have any effect at the time, but it shows how broadly unitary executive theorists interpret the clause. For half a century, Congresses and presidents have skirmished over the president's power over agencies like the board. Those skirmishes have mostly been settled by negotiations and compromises that allowed each side to claim victory. But our new administration scorns compromise. It thinks negotiation is for suckers, and it regards Congress as a mere speed bump on the road to making America great again. The president has busily been firing independent officials, not for the reasons specified by Congress, but because they are not loyal to his vision, or because he objects to actions they took in the past, or for no stated reason at all. Under the Trump Unitary theory, the president must be able to fire even federal civil servants, non-political federal workers whose jobs are nonpartisan and who are by statute protected from firing without due process. Unitary executive partisans like to claim that this is how things must be because it's how the founders wanted it to work. But in fact, the evidence of any such original understanding is weak at best and, frankly, non-existent at worst. Presidents and Congresses have shared authority beginning in 1790 over the past 250 years. Other partisans have a different defense. They say that in the nature of things, power must be centralized in the president, so he or she can act with what Alexander Hamilton called decision, secrecy, and dispatch. But if you think about it, our Constitution in most areas divides power to prevent its misuse, rather than concentrating it to make quick, secret decisions easier. Under the new administration's interpretation, the unitary executive is a ticket to a one-man rule. As of Wednesday, February 19th, in fact, President Trump has proclaimed himself king. This is what the founders called Caesarism. It's the one thing they dreaded most. Again, I'm Garrett Epps, legal affairs editor of the Washington Monthly. Don't forget to subscribe to this podcast. Thanks for listening.